can just put it like this. I'll take the first. This is the main list. Yes. Just put a hearing. You can just put a hearing and the referral and the supplement. Just use this. Very easy. Yes, Mr. Mehdi. Item number 2.
Two, my lord. For respondent 2, I am instructed to appear in this case, my lord. I have not.
This is that criminal petition, release of vehicle.
Yes, it is, my lord, is related to, my lord, the Aadhaar card. This Aadhaar office is also made respondent 2.
Who is respondent number 2?
Director.
My lord, I'm appearing for respondent 1 in this case.
You are respondent number 2?
1.
1. And where is the petitioner? Is the petitioner here?
This is part 1 list. Did it come up, my lord? When
My lord, Deputy Director, Uday, Regional Office, Guwahati.
Miss Linda, I think this is a state petition.
Yes, your lordship. Notice is, has been served. And my lord, since it's a part 1 matter, let it come up when the matter is called for, my lord.
Yes, Mr. Mehdi. Mr. Mehdi, why are you making a mention of item number 2? It will be just called. Please wait.
Yes,
my lord, I am not received the copy, my lord. I am not received the copy.
Just wait for your turn, Mr. Mehdi.
Yes,
why are you
my
making
lord,
a mention of item number 2?
Yes, my lord.
Yes. Any more mention or we call the list?
Lordship, a prayer on behalf of Mr. PD Nair on item number 4, Your Lordship.
Item 4?
Yes, Your Lordship.
Yes, what do you want?
If this can be listed on 28th of August.
And item number 4. I thought I would have disposed that. I was almost sure that I would have suspended the sentence. Where were you one time now?
Your Lordship, he's an outstationed.
I understand. I was almost.
Yeah. Sure.
Miss Linda, are you appearing in this matter? I think this is a 5-year term, right? 5-year, and the trial is completed. During trial, the accused perhaps was inside the jail and has not misused the liberty granted. Please check that. If that is so, I will allow it. Miss Counsel, in the meantime, you speak with Mr. Nair that in case the court wishes to dispose and allow whether he has a problem. All right. And if after hearing I feel that no, I will not allow, then we will accommodate you.
Yes, Your Lordship.
Okay.
Obliged.
Yes, any more? Miss Linda, but please check that part, okay? Ask one of your junior to check. Yes.
Daily list for admission, item 1.
Item 1. Review, yes, Mr. Divedi. Mr. Lalramenga,
yes, my lord.
15,000.
Yes, yesterday they have said about 15,000. I have talked to the client and they have said that if they could come down to 25,000, my lord.
They are not going to come.
Yes. 15,000 is very less, Your Lordship. So of 25,000 now.
All right, I am posting the matter for further hearing next week.
Next week.
Video conferencing mode.
My lord.
All right? Because it's a review petition. This review is, I think, it is tagged to me because it's my order. So, and I don't feel good that a review pending, a petition should be kept pending for a long time.
My lord.
Since from next week, I'm going to be sitting in the principal bench. But nonetheless, Mr. Divedi, I think since you are appearing through video conferencing mode only, so we can have it next week.
Absolutely, Mr.
Right?
Absolutely.
In the meantime, if anything further comes, we will see.
I'll communicate, Mr.
Otherwise, on the next date, I am disposing of the case.
Please.
Arguments, I take it, has been completed.
It's a matter of amount. It's a matter of amount only, my lord.
Sorry?
It's a matter of amount only.
That's right.
Yes.
That's right. So I take the hearing to be completed in the matter of amount. If any one of you comes up with something and you both agree, then we will see. Otherwise, I will pass the judgment on that day.
My lord.
My lord, if I may be able to submit a calculation of the rental agreement.
Yes, please. I'm not taking that on record, but I'm keeping it with me today. Please give a copy to Mr. Lalramenga.
The idea only is
Yes, my lord. I will serve a copy of the same. I will serve.
Thus, the idea is that we have taken in the adjoining
Very
areas
well,
the lead.
very well.
Yes.
I'm not taking them on record because I cannot take them on record. It's a review
Absolutely, no.
petition, and these can't be new facts, isn't
Absolutely,
it?
absolutely.
So all that thing also comes, isn't it?
Yes.
Anyway, as prayed for, relist on give Thursday date next week and through video conferencing mode.
Oblige.
Much obliged, my lord.
This file will go.
Item 2.
My lord, in this case, my lord.
Yes, Mr. Mehdi, what is the problem?
Yesterday, I am instructed to appear in this case for respondent 2, Deputy Director Uday, Regional Office,
So
Guwahati.
you are going to appear for respondent number 2.
Oh, yes, my lord.
And who is
So,
appearing
I-
for
I-
1?
My lord, I'm appearing for respondent 1.
You are for 1. So service is completed?
Yes, Your Lordship.
Yes,
Only 2
Only
respondents?
2 respondents.
So when do you want it?
my lord, on 4th of August, my lord.
That will be too late, 4th August. Yes,
Yes,
Miss
ma'am.
Linda?
All right, my lord, 4th of August.
Heard MS Linda, learned so and so, learned PP. You are appearing as a PP here?
Yes, Your
Learned PP for the state respondent. Also heard Mr.
Cross
Tia.
Ming Thanga.
Huh?
Cross Ming Thanga.
So and so, learned counsel appearing for the respondent number 1 and Mr. S.K. Mehdi, learned counsel appearing through video conferencing mode for respondent number 2. It appears that the service in respect of the respondent stands complete as prayed for, relist on such and such date to enable the petitioners to file it's a criminal petition.
Yes, Your Lordship.
I don't think anything is required to be filed here.
My
It's
lord,
not
lord,
required, my lord.
My lord, if necessary, I'll file objection, my lord. If necessary, I'll file.
my lord, if I may, I would further pray time for submitting my affidavit in opposition as well.
To file objection if they desire.
Well, my name may-
And
name
list,
may-
relist for admission. Huh? I think it will come for admission
Yes, Your
then.
Lordship.
Well,
You have not got your copy,
yes, my lord,
Miss Linda.
We have sent it through AD card, my lord.
So it's all right now that
We
he is
can-
appearing.
yes,
I
yes, we
think
can serve him
Mr.
again.
Mehdi, please ask one of your local.
yes, ma'am. Only my name may be reflected, my lord. On
Miss
name
Lin-
may be reflected.
You see, you don't need orders from the court for copies when it comes to Miss Linda. She
Yes,
will
ma'am.
definitely give it to you. You simply have to ensure that somebody asks her. Right?
Yes, my lord, yes.
All right. Yes. Next matter.
Item 3.
Obliged.
Yes, counter.
Your Lordship, in this matter, Mr. P.D. Nair requested me whether
Counter.
it could.
What happened to the counter affidavit? Filed or not filed?
Not filed, my lord.
So Mr. Nair wants time.
Yes, Your Lordship, if
But
it could be taken upon.
counter has to be filed by the respondent. Mr. Nair is for the respondent.
He is for the petitioner, my lord.
Yes, sir.
Petitioners.
Yes. How much time?
3 weeks, my lord.
You want me to adjourn the matter for granting time for filing counter affidavit or on the basis of an adjournment sought from the petitioner lawyer? Now tell me, Mr. Lalramanga, what should I do?
I'll put this into Your Lordship.
MS,
My lord, it may be taken up on 28th August.
Mr. Lalramanga, learned counsel, appears on behalf of Mr. P.D. Nair, learned counsel appearing for the petitioner. Stop. Also heard
Baby
MS,
Laldin Zwali.
so and so, and MS.
Lalun Lu,
So
Your
and so, learned government counsel appearing for the respondents. Both the counsels seeks further time to file counter affidavit. Prayer is allowed, released on such and such date
28th
to
August.
enable the respondents positively file their return by the next date of listing.
Much obliged.
Item 4, hearing.
Yes. Miss Linda? Miss Vani, you're appearing?
Yes, Your Lordship. And Your Lordship, I'm sorry I didn't bring the case record since
Why?
Mr. Nayard informed me that he is going to adjourn the matter.
I am allowing it.
Yes.
Yes, Your Lordship, I have already prayed for adjournment, Your Lordship.
Huh?
I have already prayed for the adjournment for the 28th of August.
Miss Counsel, you have prayed for adjournment, but this court is also conscious that somebody is inside the jail. And this court, after seeing that it has come for, this is for suspension of sentence, 5 years term, and that person has not taken any undue disadvantage of the liberty granted earlier and has participated in the trial and is also satisfied that there are sufficient prima facie grounds of appeal, wishes to allow the bail, and now you're objecting to that as an officer of the court?
No, Your Lordship.
You're objecting?
No, Your Lordship. I was just mentioning.
As a counsel for the petitioner? You see, I understand that you have been instructed by the outstation lawyer, but please be alert as what is happening in the court, because you are also a lawyer. You are not a law intern or a law student, isn't it?
Apologies, Your Lordship.
So please follow what is happening in the court. It is not necessary that what you have been asked will only happen. Don't take the court proceedings granted. The court is trying to help your client, and you are repeatedly asking for an adjournment. That too when a person's liberty is at stake. Are you understanding the seriousness of the matter?
Apologies,
When the
Your Lordship.
court is ready to set that person free, you are again repeatedly saying, adjourn the matter. Yes, Ms. Vani,
Yes, Your Lordship.
you want to have a look at the records?
Yes, Your
Please
Lordship.
have a look at it. I'll take it up after finishing the other matter. Please give it to her. Ms. Vani, I think he was on bail during trial. Just check that.
Yes, he was on bail and he
Yes.
absconded. He is the absconder.
Just check.
Yes.
Because if I am not in a position, then I will not, I'll adjourn it. But most likely, because it's a 5-year term.
Yes.
And I'm giving you one of the case law, please have a look at that. The latest case law of Apex Court for suspension. Michael?
Supplementary list for referral, item number 5.
Where is the lawyer for the petitioner? Yes?
My lord, this is proposed for mediation, my lord. Or,
Agreeable?
no, your lordship, this is regarding service matter, your lordship. I
No,
don't think.
this is item 21
Oh,
of the
oh yes, sorry, my lord.
supplementary list.
Mr. J.H. Ramne, Moya's matter.
This is not this list? No. Oh, there are 2 supplementary lists. I'm sorry.
This is for mediation, my
I
lord.
didn't realize that there are 2 supplementary lists.
Yes, this is for mediation
All right,
proposal.
all right. I understood. So are you ready? Is both parties ready for
Mediation.
making an endeavor for sorting out the dispute by the mediation
I'm sorry, my lord,
mediator?
no.
Your Lordship, the case was referred only yesterday, so
All right, then you consult the clients. I'll give you time.
My lord, I have consulted already. This matter being the service matter, so I don't think it could be appropriate for sending it to
They
mediation.
are not.
They are not
agreeable.
agreeing, my lord.
All right. Heard Mr. Lalre Menga, learned counsel appearing for the petitioner. Stop. Also heard MS Lallun Rui, right?
yes, Your Lordship.
Learned government counsel.
Yes, Your Lordship.
For the respondents. This matter was listed today under the column for referral to the special mediation drive, mediation within bracket for the nation, within quotes. And prior to listing the matter under the aforesaid column, parties have been notified as whether they wish to solve the dispute involved in the writ petition through the mediator appointed by the Mediation Center of the Aizawl Bench, Mizoram, Aizawl Bench, Guwahati High Court. Stop. Today, when the matter was called, Mr. Lal Remenga submits that the petitioner considering the issue involved in the writ petition being a service matter, does not wish to solve the dispute through a mediator, and accordingly seeks listing of the matter in the usual course. That being so, let the matter be listed in the usual course.
Much obliged.
Item 6.
Yes.
My lord, in this regard, in the present petition, I also do not have any time to
All right.
consult my client.
This matter has been listed. Follow the same pattern, Mashwa, under the so and so column, and parties were accordingly notified. However, when the matter was called, Mr. So and so, learned counsel appearing for the petitioner, submits, and MS so and so submits that they are waiting for instructions from their clients as whether they are agreeable to have the issue involved in the aforesaid writ petition solved by a mediator. Relist after
a week, my lord.
After a week on a date to be fixed by the registry.
Item 7.
Yes?
Please, Your Lordship, this is a service matter, so it is listed for
No,
mediation.
have you informed your client? You see, I understand it's a service matter, but there is a Supreme Court, Apex Court judgment under which certain categories of cases were asked to identify. Accordingly, these matters have been identified and you have been notified. Mediation Center has been in the meantime constituted, and a list of mediators have also been empaneled by the State Legal Service, Mizoram State Legal Service Authority. So, check with your clients.
No, my lord. In view of the facts of the case, it will not be.
You see, Mr. Counsel, this is not your calling.
Yes.
It is not your calling.
Yes, my lord.
It is the client which the court is interested. So kindly notify your client as regards the order of this court, and ask if both parties are willing to have the matter resolved. As counsels, as officers of the court, you must be more interested in getting matters resolved, not pending in the high courts. If matters can be resolved, why not? Making an effort, nobody loses anything, right? So at least have your instructions. If after instructions your client is saying no, then we will not force your client. But you have not even consulted your client. On your own you are saying no. That should not be. That is not a correct approach. Have you understood what I am saying?
Yes, I am.
So I am giving time.
Yes, my lord.
The same thing, and say that awaiting instructions.
Item 8.
Yes, instructions.
Yes, Your Lordship. For the State Council.
State is agreeable.
Yes, Your Lordship.
Agreeable.
No, Your Lordship, we have to seek instructions as to whether.
Okay, and what about you?
My lord, I have to take instruction.
All
from my
right,
client
same
also.
order.
Item 9.
Instructions or no instructions?
Yes, my lord, this too is a service matter.
Huh?
Service matter, this.
Mr. Counsel, why are you all not attentive when matters are taken up by the
Yes,
court?
instruction is
I'm
fine.
not, huh?
Yeah.
You have instruction.
I will consult with my client.
So then say that. That's why I'm asking instruction, no instruction. Why are you saying service matter?
Right.
We know this is a service matter. The same, await instruction.
My lord, I have one submission. I have the authority to represent respondent number 3 and 4, my lord. I will file my power within the course of the day, my lord.
That you do. And in the meantime, so and so is at liberty to file power in respect of respondent numbers
3 and 4, my
3
lord.
and 4.
Highly obliged.
Item 10.
You also obtain your instruction.
Yes, my lord.
Instruction, no instruction.
Your Lordship, the matter was, the referrals were just made known to us
This
yesterday.
council simply answer one word. Instruction.
Instructions, Your Lordship.
Okay. Instruction.
Yes, my lord.
Same. The purpose, the objective should be to minimize the judicial time. Otherwise, we are wasting time. No.
Item 11.
Yes. Instruction, no instruction.
I will seek
My lord,
instructions, Your Lordship.
sending for the mediation is appropriate in this case.
You are agreeable.
Yes, my lord.
Yes.
I will have to seek instructions on that regard, Your Lordship.
In this is item number
11.
In item 11, you say heard MS Jacinta so and so, learned counsel appearing for the petitioner. Also heard MS Lalunri, learned government counsel appearing for the respondents. MS so and so submits that her client that she has received instructions from her client that the matter can be sent to the mediation center for making an endeavor to resolve the dispute involved in the writ petition. However, Ms. Lalunri is yet to receive her instruction and accordingly seeks posting of the matter on another date. It is expected that by the next date, state shall also come up with a positive instruction so as to make an effort to settle the dispute involved in the writ petition, inasmuch as such matters are keeping such matters pending for adjudication is of no use, and if such matters can be resolved amicably, the same should first be tried. Released.
It's a place.
Item 12.
Released that same thing on such an. Yes.
No instruction, madam.
All right. Await instructions.
Item 13.
Yes.
Lordship, no instruction, but keeping in mind the nature of this case, it may be appropriate to refer the matter.
Appropriate to?
To refer to the mediation.
Refer. But you see, the problem is the party should be agreeable. It is not about, you can obviously convey your, I appreciate that submission coming from a lawyer, so you try to utilize your good office and tell them what is good for them, isn't it? So, and come up with that instruction. All right. And in fact, you say, however, Mr. So-and-so, learned counsel appearing for the petitioner fairly submits that. Should I say that? All right. Not
let it be silent also.
All right.
Item 14.
Marshman?
No instruction, my lord.
Try to record both sides' names in all the matters. Same, huh? Instructions. Await instructions.
15.
Yes.
Yes, my lord, no instructions.
No instructions. What about other side? Respondent. Samuel, Mr. Samuel. Okay, put Mr. Samuel's name. All right. Just let me know whose name has to come.
Yes, Mala.
Yes. Take your instruction.
Item 16.
But state councils, Mr. Samuel, additional AG and Ms. Linda, if she's also there.
Miss Caroline is appearing on behalf of the state, my lord.
In this matter.
In this matter.
But since you are an additional AG, so I am.
As a standing counsel for NHIDCL, I am appearing in this matter.
Okay, okay. Otherwise, you must also sensitize your officers.
Yes, my lord.
And also the state concerned that, you know, since this is an effort
yes,
which the High Court, this drive is going on. So, a positive effort should also be made on behalf of the state.
Yes, ma'am.
Isn't it?
Will do, ma'am.
So please convey that message to your respective clients.
Will do, ma'am.
I am telling you because you are holding a post.
I understand,
and so you can always make good use of, utilize the good office that you hold.
Yes, ma'am.
Yes. All right. Instruction, right? Same.
Item 16.
Yes.
My lord, I have spoke to my clients, but it seems there is no possibility outside court settlement.
They are not accepting.
Yes, my lord.
Yours is item
16, my lord.
16. Heard Mr. Victor so-and-so, also heard MS Lalun Rui, Learned Government Council. This matter was that first order, same order. Okay?
Item 17.
Yes.
Lordship, in pursuance of this Honorable Court order, I have taken steps upon the respondents number 4 to 9 on 2 7/20/25 and
You are
every card.
appearing for respondents.
I'm for the petitioner, Lordship. I have taken
so
steps upon the
these
respondent.
steps is not complete.
Not completed, Lordship.
Okay. Though this matter has been listed today under so-and-so column, however, it appears that service in respect of respondent number
4 to 9.
4 to 9 is still awaited. Let registry verify and place the matter accordingly.
Item 18.
Yes, my lord, I'll take instruction in this case.
All right. Instruction await. And Ms.
Same for the state
Lalundri
as well, Your
and
Lordship.
MS so-and-so.
Item 19 and 20.
Yes. Agreeable.
Lordship, in this 19 and 20, yes, it's same nature. So my client is willing, has a willingness to refer the matter for
Willing?
mediation. Yes.
Your client is willing.
Yes.
I will have to seek instructions.
What instruction? You are state.
Yes, Your Lordship, but I would still need to notify the state as well.
Mr. So-and-so, learned counsel appearing for the petitioner submits that he has received instruction that that the petitioner is agreeable to have the matter resolved through the mediation center of the Aizol bench so-and-so. MS so-and-so submits that she may be given a short accommodation in order to seek instruction from the state respondent as whether they are willing for so-and-so. With hesitation, though, don't say that. Prayer is allowed, however, it is expected that the state respondent shall endeavor to shall respond positively to the mediation drive undertaken by this court in terms of the decision, judgment and order dated so-and-so of the Supreme Court. Released so-and-so. Yes, Mr. Jordan?
My lords, if your lordships is willing to take a part 2, my lords, we would.
Okay, all right. This is over?
That's over.
Second supplementary list. Item number 21.
Seizure. Yes. Why is the vehicle being seized? Who is appearing?
Miss Mary.
Miss Mary? Mr. Samuel? Can you ask someone to inform Miss Mary?
Yes, my lord. They're on their way, my lord.
Which order?
The order is at page 22, my lord.
You had earlier filed a JIMA petition?
Yes, before 2 times before the learned trial court.
2 times?
Yes, 2 times rejected.
Just one second. Did you get that order? Call him. Come here. Then give it back to me. Yes, please.
Yes. The rejection order is at page 22, the first one. Yes.
Page 20?
22.
Yes.
Then another rejection order is at page 24.
Yes, the second order
is at page 24, from 24.
Has anybody informed Miss Mary? She's on her way. When was it seized?
On 27/09/2023. 7/09/2023.
27/09/2023.
2023. Yes.
And twice rejected.
Yes.
I think you have a case of, but only thing we might dispose it on by saying that, by quoting Sundar Bhai's case.
Yes. I
And
have the
you are
judgment
carrying it.
also. Yes.
So in terms of that, we will say we'll ask you to approach the so-and-so court, and in accordance with that, by taking proper so-and-so, let them release it. I think that order would be fit.
But at least, my lord, the bond may be fixed by this court.
Sorry?
The bond.
No. Why should we fix? Okay. But where is your counterpart? If she is here, I could have passed the order. She's not here.
If the matter may be passed over for the time being, because Ms. Linda is on legs in the other courtroom.
Okay.
You please have a copy of. All right, I have a copy. Sundar Bhai Ambala,
Yes,
you have,
I
right?
have.
Very well. I have a copy also.
My lord, if I may.
No, it's all right. I have a copy.
Okay.
Daily list, item 4.
Have you asked for this? Just give this to. Ms. Vani, I had asked him to get those Apex Court decisions which I have referred in that judgment. They are coming from the library, but in the meantime, just see this order once. You will understand what the Apex Court has emphasized.
Okay.
So just see that. Mr. Jordan, which is your matter?
It is the last item in part 2. I understand your lordships, it is the...
It's a criminal appeal.
My lords, it's a service matter.
Service matter. This bench is only there for
my lords,
just tomorrow, and I think about 4 or 5 criminal appeals I have already disposed of.
Yes.
It's just that some editing is going on. I will
see.
have to sign them before I leave.
My lords, in fact, I've just been informed that certain some of the matters in part 2 are relating to the liberty of the petitions therein. So, my lords, I'll give way.
So that then you have it next week?
Next week.
All right. Which matter? Item number? 15. Item 15, so-and-so, heard Mr. Jordan so-and-so, and who's there in other side? And also heard MS so-and-so, Learned Government Council, as prayed for, relist after a week, or next week?
Next week.
List next week on any date to be fixed by the registry.
Grateful, my lords.
Yes.
Lordship, we have in item number 7.
Of part 2?
Yes, of part 2.
7. You've read?
Yes, sir.
All right. Call that item, Ms. Vani's item.
Item 4.
So keep that principle in mind and make your submission.
I understand.
Yes, please.
Yes, Your Lordship. After reading the judgment.
So I will then.
Yes.
All right. Heard MS.
Kevinisia, Your Lordship.
So and so, Learned Counsel appearing for the petitioner on behalf of Mr. P.D. Nair, Learned Counsel for the appellant. Applicant. Now is this an interlocutory applicant? Stop. By way of this application, the applicant, Mr. Mustaqur Rahman, is praying for bail stroke suspension of sentence of the suspension of the impugned judgment and order dated 2/6/2023 passed by the Learned Special Judge Prevention of Corruption Act Mizoram in capital SR within bracket PCA number 04/2018, whereby the applicant was convicted under sections 468/471/403 of IPC 1860, read with section 120B of the said code, and sections 13(1)(d)/13(2) of the Prevention of Corruption Act 1988, read with section 120B of the IPC 1860. It appears that thereafter, by the impugned order dated 5/6/2023, the appellant was sentenced thereof to undergo imprisonment for 5 years and with fine of rupees 5 lakhs, and in default to undergo imprisonment for another 5 years, each for offence under section 403, read with section 120B IPC, section 420, read with section 120B IPC, section 468, read with section 120B IPC, and section 13(2), read with section 13(1)(d) of the Prevention of Corruption Act 1988, and section 120B IPC, with fine of rupees 5 lakhs and in default imprisonment for another 5 years. Stop. And all the sentences except fine were to run concurrently. It appears that the applicant was arrested on 22/2/23, and since then he is in judicial custody, and even on the day of delivery of the impugned order dated 5/6/2023, passed in SR within bracket PCA number 04/2018 by the Learned Special Judge Prevention of Corruption Act, Mizoram. It appears that by the impugned conviction and sentence, the petitioner has been sentenced to undergo a fixed period of imprisonment. Stop. In the in Kiran Kumar versus State of MP, reported in 2001 9 SSC at page 211, the apex court emphasize that in a given case when a person is convicted and sentenced to a short-term imprisonment, the normal rule is that when his appeal is pending, the sentence should be suspended, and rejection is only by way of exception, and be put forward for such rejection. Paragraph 3 of the aforesaid judgment reads as hereunder, quote unquote. In the case of Atul Ellis Asutosh versus State of Madhya Pradesh, reported in 2024, volume 3 SSC at page 663, the apex court has held that when there is a fixed term sentence, and especially when the appeal is not likely to be heard before completing entire period of sentence, normally suspension of sentence and bail should be granted. Stop. In fact, the apex court in the aforesaid judgment expressed its opinion that such cases should never be required to be brought before the apex court. Stop. Paragraph 4 of the aforesaid judgment reads as hereunder, quote unquote. In the case of Bhagwan Ramashindi, Gosal and others versus State of Gujarat, reported in 1999, volume 4 SSC at page 421, the apex court have said that when a person is sentenced to a fixed period of sentence and when he files an appeal, any statutory right suspension of sentence can be considered by the appellate court liberally unless there are exceptional circumstances. Paragraph 3 of the aforesaid judgment reads as hereunder, quote unquote. Reading of the aforesaid judgment, it is absolutely clear that when an appeal is pending against a conviction and sentence where the sentence is a fixed short term of imprisonment, the appellate court should liberally consider the prayer of bail and suspension of the aforesaid conviction and sentence. And only if an exceptional case is made out, a rejection may be given. In the present case, no such exception has been brought to the notice of this court, nor this court has seen on perusal of the materials available on record. That apart, the grounds of appeal appears to be substantial, prima facie substantial and good grounds. Hence, under the given circumstance, hence, accordingly, don't say. Accordingly, the operation of the judgment and order dated 2/6/2023, passed by the learned special judge, Prevention of Corruption Act, Mizoram, in SR within bracket PCA number 04/2018, including the conviction of the appellant therein and the sentence passed thereof by order dated 5/6/2023 remains suspended during the pendency of the connected appeal. Stop. Considering accordingly, this court allows the accused appellant to be released on bail, subject, of course. Yes. Subject to what? Furnishing any bond?
Yes, Your Lordship.
Subject, of course.
Two surety, my lord.
Huh?
Two surety with a bail bond of 50,000 at least.
Two sureties, bail bond of 50,000. Okay. Accordingly, the interrogatory application stands disposed of. Yes. Now you are smiling. Huh? See, I understand you probably may be very fresh in the bar. But, when an instruction is given to you or an outstation counsel makes a request to you, you also be alive as what they have asked and see what is the case.
Yes, Your Lordship.
Don't come before the constitutional court merely because somebody's asked you to. You must be aware of what is the case and what is that adjournment that you are seeking.
Yes, Your Lordship.
If the court is giving you which is in your favor, why then to take the adjournment? Isn't it? I don't think Mr. Nair is going to be disappointed with you when you inform him today that you have got this order. I think he's going to be proud of you, rather.
Yes, Your Lordship.
Yes or no?
Yes, Your Lordship. Much obliged, Your Lordship.
Acha, Miss Counsel, in the main appeal, you want a particular date?
Yes, Your Lordship. If this could be fixed on the 28th of August.
All right. In the main appeal, as prayed for, list on such and such date.
Obliged.
Item number 21 from the supplementary list.
But you change them. Ask for OP. Because they've got one disposal. Ask it.
Okay.
Yes, Miss Mary, why to keep this vehicle in the police custody, Sundarbai?
Your Lordship, I do not have much objection in the matter.
No, I think I will allow it.
Yes.
Because you are aware of Sundarbai Ambala al Desai.
Yes.
Only help me in when I'm giving the direction.
Yes, all right.
Because I think no use of sending, or should we say that we direct the magistrate, the trial court. Is it the trial court or which court?
The NTNPS.
So we can also say that we can refer to Sundarbai Ambalal and say that
To the satisfaction of the learned trial
yes,
court.
we will allow it and subject, of course, satisfaction and identification verification.
Yes.
Isn't it?
Yes. Good enough.
Heard Mr.
J. Shram Nimoya.
So and so, learned counsel appearing for the petitioner. Also heard MSM Mary so and so, learned counsel, learned APP for the state respondent. By way of this application, under section 5 to 8 of BNSS 2023, the petitioner Shri Nazrul Islam Laukar.
Laskar.
Nasrul Islam Laskar.
Laskar. In Assamese, it's called Loskar.
Oh, okay. Your
Okay.
Lordship.
The pronunciation.
Laskar.
Is seeking setting aside and quashing You've actually not sought for quashing.
Yes, yes, they do not.
Is seeking for release of motor vehicle within bracket Tata 1816 LPT, brick red color, bearing registration number AS28 capital AC 1618, chassis number MAT 843014 capital P7E capital E 10439, engine number 3.3 LNGD 11 EXX 513881, comma, vehicle documents and its ignition key, which has been seized by the Excise and Narcotic Anti-Narcotic Squad in connection with where is the case number? Why you have not?
Excise case number
263 of 2021.
Where do I get? Okay. In connection with excise case number EXN 263/23 dated 28/9/2023, registered under section 21C of NDPS Act 1985. Full stop. It appears that the subject matter of the petition is the custody of the vehicle in question, which has been seized by the
Excise and Narcotics.
Excise and Narcotics
Anti-Narcotic Squad.
By the Anti-Narcotic Squad in connection with the aforesaid case under the NDPS Act so and so. It appears that the petitioner, being aggrieved by the aforesaid seizure of his motor vehicle, submitted an application 2 times before the learned judge, Special Court NDPS Act Aizol, for releasing of his vehicle on Jimanama. However, on both the occasions, I-22/11/2023 and which is the second date, and
07/02/2024
and 07/2/2024, the learned NDPS judge Special Court NDPS Act rejected the same. Order dated 22/11/2023 reads as hereunder, quote unquote, page 22. Order dated 7/2/2024, passed by the so and so, reads as hereunder, quote unquote, page 24. Situated thus, the present criminal petition has been filed. Mr. So-and-so, learned counsel appearing for the petitioner, submits that the petitioner is the lawful owner
Yes.
of the seized vehicle. And since his vehicle is a vehicle for commercial,
Yes, commercial.
and since the aforesaid vehicle is being used by him for commercial purposes, seizure of the same has caused financial hardship to him, to the petitioner. He further submits that he further relies upon the decision of the apex court in the case of Sundarbai Ambalal Desai versus State of Gujarat, reported in AIR 2003. No, reported in 2002, volume 10 SSC at page 283. Stop. Per contra, MS Mary, learned APP for the state respondent submits that it appears from the order of the judge so and so on that the prayer for Jima of the aforesaid vehicle was rejected on both occasions as the charge sheet was not filed. Stop. I have heard the learned counsels for the parties and have also perused the materials available on record. Apt at this stage to refer to the decision of the apex court in so and so. Sundarbai so and say Supra, wherein the apex court has laid down the principles in relation to the power of the trial court under section 451 CRPC to be exercised. Relevant paragraph of the aforesaid judgment with regard to the vehicles reads as hereunder. Reading of the aforesaid judgment, I am of the unhesitant view that the judge and the PS so and so ought to have passed appropriate orders by taking appropriate bond and guarantee as well as security for return of the said vehicle, if required at any point of time, inasmuch as it is of no use to keep such seized vehicle at the police station only for the purpose that the said vehicle was used for transporting recovered alleged contraband articles. That being so, the aforesaid order of the trial court of the judge so and so, whereby the custody of the seized vehicle to the petitioner was rejected, is totally erroneous. Resultantly, considering the principle settled in the case of Sundarbai Ambalal Desai Supra, the prayer for Jima of the seized vehicle bearing registration number so and so, registered, which was seized, which was seized, give all that details, and then say which was seized in connection with so and so is allowed. As such, the investigating officer only, right, Mary?
Yes, Your Lordship.
Is directed to release the seized vehicle. Give the details, I so and so, to the above named petitioner on his proper identification and on verification of all the relevant documents relating to the said vehicle in original.
If I may, my lord, it should be the trial court in DNPS.
Trial court?
Yes,
Or
yes.
instead of the investigation officer.
Special judge.
Special.
Okay. Instead of IO. So and so. And after taking photograph of the said vehicle and on furnishing a Jima bond equivalent to the market value of the seized vehicle, with further condition that the petitioner shall not alienate the said vehicle and shall produce it before the trial court whenever it is required in the case during the course of trial. I think that should be sufficient.
It's sufficient for the prosecution, but then.
No, for you, I have taken all the necessary,
Yes, yes.
whatever is given before, the conditions which has been
Yes.
stated in Sundarbai.
I was just thinking that
Yes.
the value of the
The
motor
value.
vehicle would be. I don't think that.
That
let him
bond,
submit. Let him submit.
that bond may be
Let my
reduced
management submit.
with.
It's a bond. Hence, the criminal petition stands disposed
Yes,
of. No, then I think I should set aside this. In view of the aforesaid, the orders, those 2 orders of so and so are also hereby set aside and quashed. And because its inherent power is there,
Yes.
he may not have. And the criminal petition stands disposed of.
My lord, if I may interrupt one, that bond which would be equivalent to the value of the seized vehicle may be reduced to.
Reduced to what?
1 lakh or 50,000, something like that. It's a trap. So
You want your vehicle or not? You want your vehicle or not?
we want the vehicle, but
And you are using it for commercial purposes?
yeah, it was taken on loan.
You are not a driver.
Yes.
You are a businessman. All right.
Hearing list, item 2.
Anyway, when I do my final checking, I might reduce it. I am not promising anything. Please don't anything. Until and unless the judge signs, you don't know.
I will appreciate.
Done? Hearing list. What is this, Mr. Lalremenga?
Hello, this is a jail appeal wherein the appellant by judgment in order 9/4/2019 was convicted and sentenced to undergo 10 years.
Pokso?
RI. No, my lord, NDNPS case. And the seizure of ganja, 20.150 kgs.
Only thing, I am yet to finish another 4 of the
Yes.
POXO appeals. I
understand.
am not available next week. I'll have this matter next week.
It may be listed again after a week, my lord.
Yes. A spriteful list after a week on a date to be fixed by the registry.
Mucho much.
Done, na?
My lord, hearing list, if I am allowed to make a mention, my lord.
Yes.
Item 9 and 10, I have spoken to Mr. Malhotra.
Yes.
It is Mr. Malhotra's case.
Yes.
This may be taken up after a week, my lord.
All right. Item?
Item 9 and 10.
9 and 10.
Tagged together.
After a week, as
Yes.
per it, on a date to be fixed by the registry.
Highly obliged.
All right.